looked at me, though, and he said, son, he said, I'm proud of you, and you're a lawyer now. He said, but if you think that's the end-all, be-all, you need to move on. And I couldn't really figure out what he was talking about until, he really wanted me to know that, hey, look, you still got to roll your sleeves up. You're going to work harder than you think you should. You haven't made it to a point of coasting.
That was criminal defense attorney Steve Frey talking about his father's reaction to the day he passed the bar and became a lawyer. His father was both proud of him, but also was being tough on him, telling him that the real work was beginning at the moment he became an attorney. I was grateful to spend an hour with Steve talking about his development as an attorney, his decision to go to law school, and some of the things he's learned along the way in many years of criminal defense practice. You're listening to the Advocates Key podcast. For more information about this podcast and more about my practice, you can check us out at scottkeylaw.com or give me a call at 678-610-6624. Steve Frey, how are things?
I'm wonderful. How are you?
I am good. So it's really good to have you on the podcast. When I figured out that I wanted to start this up, you were one of the first people I thought about. You were probably one of the first lawyers I met when I first started practicing. And of course, I know very well who you are. But for those who are listening, who is Steve Frey? Just kind of take a second to introduce yourself.
I'm a lawyer. I practice in Jonesboro, Georgia. I grew up in this town. I love this town. I no longer live here. But my father practiced law here, and I practiced law with him for a while. And then he passed away, and I've been practicing solo since he passed away in 2000.
And talk a little bit about Pete Frey, your dad. I never actually met him. I think when I was a third-year law student was when he passed away. And, of course, I worked in Jonesboro when I first started out with Lee Sexton, and he's told me stories about you and he's told me stories about Pete, but tell me about Pete and what it was like growing up with Pete as your dad and what it was like practicing with your dad.
He was my hero. He was a cowboy. He was a first-generation college graduate. He put himself through school. He married my mother while he was still in undergraduate school, and my mother put him through law school. And he came out of law school, worked for a couple of firms, and then decided to try it on his own. We moved to Clayton County in 1971. He was elected state court solicitor in 1972. At the time, it was a part-time job, so he was able to practice law and be the solicitor. And then I think around 1982, they made it a full-time job, and John Carbo became the first full-time solicitor in Clayton County.
And when did you start practicing law, or when did you go to law school?
I went to law school in 1990 and graduated, passed the bar in 93. Was sworn in by Bill Eisen.
Well, so for people who don't know who Bill Eisen was, talk a little bit about Bill Eisen. I sort of remember him from when I first started practicing, but kind of paint a picture. What was it like in the 80s and early 90s to practice in Clayton County, Georgia? What was everybody like? You talk about Pete and
it was a smaller group. So there was they had a snack bar in the Clayton County Courthouse, and that was a point of a lot of social contact. There was a lot of camaraderie. Judge Eisen had been an assistant district attorney, and then he was the elected district attorney, and then he became a Superior Court judge. And without going into many quote-unquote Judge Eisen stories, he was like having a big brother that used to just beat the snot out of you so that whenever you went anywhere else, you weren't afraid of any judges. Mm-hmm. So he was wonderful in that regard. I do remember the first, or at least the last time I ever used the words judicial economy. And he pointed out to me that judicial economy was him calling my case for trial right now. And I pointed out to him that wasn't necessary. But, he was He's still doing some senior judging. He's a little on up in age, but he really was that judge that you kind of felt like whenever you left your circuit and you were hunkered down and the whole world was after you and your client, and you were getting menacing glares from a judge. I'm not here to say that was comfortable by any stretch of imagination, but you knew you'd been there before, and you knew that you could survive this.
So talking about your dad, and I know, and I don't know how much you want to talk about all this, but I know that from stories you told me in the past that maybe as a teenager, I don't know if the word rebellious is the right word to use, but I know that maybe things were difficult between you and your dad when you were a teenager. Talk a little bit about your dad back in those days and sort of the path that you took from there to become a lawyer.
Rebellious would be the most polite word. Like I said, I was not a good student really at any level of school. I somehow was able to pass every test that mattered. But when I was in high school, my father had a dragster. And so we drag raced on the weekends. And that's what I thought I wanted to do. And when it came time to graduate from high school, I think my mother overheard me tell somebody that I wanted to drive a funny car for a living. And I think within 6 months, everything race car had been sold. And my mother had me at Clayton State enrolling me. And as always, my mother was correct.
What about, so was your mom the formative one when it came to sort of, she cleaned house and took care of the race car stuff when you were talking about that? What was your relationship with your dad like in that time?
He was an alpha bear, without a doubt. And he cast a large shadow. And so sometimes we clashed. He used to have a saying that, hard head makes for sore rear. And I put him to task. I wanted to prove to him that I had the hardest head in the world. And he was more than willing to prove to me that he could redden my rear end.
So beyond just, enrolling in college, did you know going into college? I mean, it sounds like that's something that your mom sort of not compelled you to do, but maybe compelled you to do because she didn't want you to take a career path that she thought maybe was dangerous or wouldn't be potentially lucrative or could have been destructive. So she got you to college as a way to steer you away from another thing. But when did you decide that you were going to go to law school?
Again, I was not the best student, so I wanted to be like my dad. I cycled through college. I realized that, now's the time to enter law school. I took the LSAT. I had an LSAT score. I shopped myself to the law schools, ended up going to night law school, had a professor at Georgia State tell me that I needed to go back to college and, improve my grades, come back with a little better track record of being a better student. And my father stepped in and said, no, you're going to night law school and you're going to pass the bar the first time you take it. I went to night law school. I'm not going to say that I became a great student then, but I did have some successes. And every time I pointed those out, my father would tell me that, he thought that was wonderful, but that it was going to be sad when I failed the bar. So when the bar rolled around, it scared the living daylights out of me. And he was kind enough to give me a leave of absence for about 60 days. And I, what were those PMBRs? Yeah, I put my head in those PMBR books and took those multi-state tests over and over and over again. By the grace of the good Lord, I passed the bar the first time.
So when you were in law school, you were working for your dad, and you were working in your dad's practice then?
I was.
What was your job, or what was your daily routine? What was your daily routine like when you were in law school?
We went to school at night. So I, along with most other students, non-traditional law school students, most of us had 40-hour jobs. So my day would begin here at the office. My father would dispatch me to do certain things for him. Some of the judges would have probably accused me of blurring the lines a little bit, a couple of them hollered and screamed at me. But, I did what my dad wanted me to do. He got sick while I was in law school. So he was able to get a cancer-free diagnosis, but it came back a couple of years after I got out of law school. So I really never had a chance to try cases with him or do anything like that. So, my job largely as a law school student was to try to be the best right-hand man I could for him. And when I practiced law along with him, he started getting sicker towards about 96 till his passing. He was sick and unable to really withstand the rigors of trying serious cases. So I didn't get a chance to do that much with him. We would sometimes talk in the evenings when I was trying a case. But, unfortunately, we never really had a whole lot of shared stories about practicing law.
So you said a minute ago that when you were in law school and you were kind of working there in the practice, that the lines were blurred. I take that to mean that probably you were doing some actual lawyering, that maybe you were pretty close to being a lawyer when you were in law school.
I was answering some calendars, kind of getting prosecutors to hold for Pete's announcement. Usually he would dispatch me within the Clayton County Courthouse. He would go where the conflict had him go first, and then I would alert the judges that, he was en route, where he was, and when he would be here. I did get a chance in my third year of law school. Matt Simmons swore me in to practice under the Third Year Practice Act, and I prosecuted some in the solicitor's office with Elizabeth Baker. She was my mentor. Longtime friend. I've known Elizabeth almost all my life. So I did get to practice law. I remember, a couple times Pete sent me someplace, and I remember one time I got a continuance because it was a preliminary hearing. And I was over in East Point in front of George Barron, who was just a wonderful man and a good judge. And I got out there and I realized it was a preliminary hearing. So I got Judge Barron to continue it and came back and told Pete. And, of course, we marked the calendar. And back then, Judge Barron would hold court sometimes in the evening hour, around 5 or something, 4:30 or something like that. So as Pete's leaving the office one day, I said, "Hey, man, don't forget so-and-so," and he kind of looked at his watch. You could tell he was a little agitated about that. And I said, "Man, they're expecting a lawyer to show up this time." And he looked at me and he said, "Well, you need to get on over there. I guess we're going to find out what you're made out of."
And you're still a law student at this point.
Yes. They weren't expecting a law school student. And bless George Barron's heart. He was kind enough to not call me out. I think he saw the predicament I was in. I ended up negotiating a plea to a city ordinance, and we took a plea and paid a fine. And I'll never forget, because the guy, Judge Barron, was like, "Well, so you're not represented by counsel?" And he turned around and I shook my head. "No, you're not." He said, "Okay." But it worked out wonderfully for the client because it went from a felony to a city ordinance, and we paid a fine and walked off. So,
you did great.
Yes, I was proud of myself. We're outside the statute of limitations, so
right.
We did practice. I did practice law a little bit there and got away with it, but the one thing that Pete did when I passed the bar, Scott, he got me in here. We had survived a tumultuous teenage years, and, I'd gotten through 4 years of college without any troubles. And I saw him cry for the first time. And he looked at me, though, and he said, "Son," he said, "I'm proud of you, and you're a lawyer now." He said, "But if you think that's the end all be all, you need to move on." And I couldn't really figure out what he was talking about until, he really wanted me to know that, hey, look, you still got to roll your sleeves up. You're going to work harder than you think you should. You haven't made it to a point of coasting So I miss him terribly. He always had a knack for summing up your circumstances in a couple of words that made sense to you, gave you some assurance that you could tackle what lied ahead.
So it sounds like that in two instances he did that. So with the bar, he said, "You're going to go to night law school and then you're going to pass the bar." But then once you got into law school and you were having a little bit of success, it sounds like he sort of used the prospect of you failing the bar as a way to motivate you a little bit.
Without a doubt.
And then when you became a lawyer, he was so proud of you that he cried about it. But he also, it seems like the second half of that was, but you're going to have to work hard. Like you haven't really done anything yet.
Yes.
And was that something that he continued to use and motivate you kind of in your early years of your practice?
He'd been a criminal defense lawyer for all I'd ever known. And so, there were a lot of other things that he told me about the practice that, I was getting into. Like, you're going to go to other courtrooms and courthouses, and you're in a profession, son, where most people are dying to tell you no. And that's
Right.
going to be,
Right.
from the bailiff to the clerk to the judge's secretary. So, you're going to need, and I think I heard you talking with Lester Tate about this, nothing replaces politicking that courthouse a little bit, getting in there, being nice to the people at the door, being nice to the people that are sitting at desks. It's just, there's nothing can replace that. And he had a knack to try to, instill in me that, look, son, no matter who you are, you still got to get past these folks, and you need to treat them with all the respect they deserve.
And so starting off in your practice, did you primarily practice in Clayton, or right off the bat were you going all over Georgia or all over Metro Atlanta?
I ventured outside of Clayton some, but, while Pete was still alive, I worked for him. So there weren't many instances where I went too far outside, about a 100-mile radius. Found myself in Gray, Georgia one time.
Jones County.
Down there wondering what have I done to get in here. Fortunately, those folks were good to me, and we were able to work something out. Since he's passed, I've been all up and down the Eastern Coast, and, been a lot of places, practiced law in a lot of different places.
Because I know at some point in time you got into some federal practice, and I think you still do a fair amount of federal work.
I do. I don't do as much as the folks that I call and lean on when I have dumb questions and pray that they have the time to answer them. But yes, my father told me, he said, son, if you're going to really be a criminal defense lawyer, then you've got to go practice in federal court.
When did you start doing federal practice?
I got sworn in, I think, by Judge Shube. But I didn't try a federal case until after Pete passed. I tried 2 cases in the early 2000s, one in Virginia and one here in Atlanta, and won the Atlanta case with a verdict, and won the Virginia case with on a motion for new trial. It's a long story. The judge just he was going to let the jury hear all of the inadmissible evidence and then deal with it after the fact. And but he was kind enough to, he told me, he said, son, get a motion for new trial in, make sure you make these deadlines. You're going to need to get admitted to I think it's the 4th Circuit. He said, you're going to need to get admitted there. And then we handled some post-trial matters in the trial court, and the trial court corrected the error it made with respect to some crucial evidence, and then entered a judgment of acquittal.
So you also mentioned a second ago that you won a federal trial in Atlanta.
Correct.
Which, for people that don't know, that don't regularly practice federal criminal work, you might go your whole career and never beat the U.S. government in a jury trial. So do you care to talk a little bit about that jury trial?
Yeah, it was, and I agree with you. For those who have never done it, it's a daunting task. To kind of lean back on another Pete story, I remember I had some federal cases. I never tried one while he was alive, but I remember him asking me, when you look down at the style of the case and you see it's the United States of America versus you and that guy sitting next to you, he said you feel a little overwhelmed, but you really feel like you're on the center stage. And so I tried a case. We ended up trying it in Noonan, the Noonan division of the Northern District. We got a little different juror than you would have gotten in the Atlanta division. Had a little talk at one point during a break, talked with the trial judge over lunch, just kind of waiting on some things. And then we talked about the case while the jury was deliberating. And he asked me, he said, a little different jury than you get up in Atlanta. I was like, yeah. But it was a methamphetamine conspiracy, and the other guy got to the government first and told his side of the story, and the government bought it hook, line, and sinker. And it was really kind of funny, Scott, because I'm running around Meriwether County trying to get some people subpoenaed, and I get the sheriff. He was the sheriff of Meriwether County, I think, at the time that he was a witness. As things change, time changes, people move into different jobs or different positions. But at the time I served this gentleman with a subpoena to appear for the defense. He was the sheriff of Meriwether County. And so when we reported on that Monday morning, the judge asked me, he said, are you ready to try the case? And I said, well, I got some subpoenas out there and I hadn't heard from these folks. And he said, who? And I told him, and he looked at me, and I didn't realize at the time that, hey, the marshal handles you.
Not you.
Not you. So I think he was a little impressed, because he asked me, you did this? And I was like, yes, sir. I drove down there and put it in his hand myself.
Mm-hmm.
And I'll never forget, we're sitting there, and of course it's a Monday morning, probably about 9:30, 10 o'clock as we're sorting all this out. He got on the phone and found where this gentleman had largely ignored my subpoena and gone to the beach. I think within about 30, 45 minutes, the judge spoke directly with that particular witness and told him that he needed to come on back. And so, and I'll never forget, because he left, we were in chambers, and I'm scared to death, man. I mean, I'm sure that I can do this, but, my stomach's in a knot. And I'll never forget, he leaves the room and he comes back in the room and he tells me, he assures me that he's handled this and that witness is on the way. And he kind of goes down a little checklist and he said, now, aside from all of these things, son, are you telling me you're ready to try this case? And I said, yes, sir, I am. Mm-hmm. And he said, okay. About 5 days later, the jury cut him loose.
Which is phenomenal in federal
Phenomenal.
court.
It was one of those things, Scott, I'm not going to lie to you. I teared up wishing, because that would have been really something I would have wanted to share with him.
Uh-huh.
Because, just as you said, the government is, they're a formidable foe. It would have been perfect if I could have been down at the King and Prince with Lee Sexton and Pete and maybe a couple other guys, and we all just told stories of that trial and others and just went, made it a long night, a good long night. But, that was a very interesting trial. We had a moment in there where the government's prime witness, who is a co-defendant, a cooperating co-defendant, a DEA agent, was on the stand basically recapping his particular position in all of this. And we got around to his proffer with the cooperating co-defendant, and I don't remember exactly what the subject was, but it was largely to the point where the only two answers that the agent could make is yes, I'm listening to someone giving me self-serving testimony, or yes, he's lying. So those were the only really two answers at the point. Uh-huh. And when we got to that point, and of course I'm feeling all Tom Cruise, Few Good Men, so I'm demanding answers, and right. The government objects, and we go to a sidebar, and we start trying to get to the bottom of the relevancy objection, and I couched my position in a term that all of a sudden I thought, I shouldn't have said that. And I don't think the court was alarmed at what I said. But I think the court's...
I think you told me this story before. So didn't you say something along the lines of, I'm not trying to screw around with the court or something?
Exactly.
And,
yes.
and then it wasn't a big deal at first. And then...
Yes. And then he looked at me and he said, over the course of about 90 seconds, he said...
But you caught it. But right, if I'm remembering right, you caught it. And you said, I'm so sorry, Judge. You said something like that. That was. I
said that was a poor choice of words.
Right.
And he looked at me and he said, yes, it was. And we continued to talk about the objection. And then he looked at me and said, an extremely poor choice. And I affirmed that with a yes, sir, it was. And then about 20 seconds later, he said, do you know why it was an extremely poor choice of words? And at this point, you're like, man, just hit me, do something, but, quit dragging this out. Mm-hmm. And of course, you've got to answer it. You've got to give him room to tell you why it's such a poor choice of words.
Right.
So, much like a bullfighter, I wave the cape, and then he comes charging at me, and he points out to me that I can't screw with him, but that he can screw with me.
Yeah.
And at this point, I'm thinking, if you don't leave me alone, I'm going to start crying,
Uh-huh.
And I'll never forget, we get to the very end of the conversation, and he's never ruled on the objection. Uh-huh. And he just kind of, and of course the DEA agent sitting over there on the witness stand all smug, knowing that I've just gotten paddled over there. So I've been told to go back to the dais And as I'm walking, I thought, you never ruled on the objection.
Right.
So I kind of turned, because I'm looking at the DEA agent like, hey, buddy, I might be a little apprehensive of him, but I'm not apprehensive of you.
Mm-hmm.
And so I'm dying to get back and begin. So I realized, holy smokes, we've never ruled on the objection. So I stopped. And at this point, it's a conversational tone of voice. And I said, Your Honor, you never ruled whether I could ask that question or not.
Mm-hmm.
And he said loud enough for everybody to hear, you can ask it from the county jail. And, of course, at that point, the agent's looking at me like, yeah, that's right. And, of course, the jury, they know that I've kind of gotten paddled a little bit. They don't really. And so, they're still looking at me like, what are you going to do? And one of the things I've noticed about jurors a lot of the times is if you can handle it respectful, there's no set of circumstances under which you can be disrespectful to the court or to the structure in which you're trying this case. But if you still stand tall and stand the gap, you'll get a little respect from them, even if they look around and go, well, I don't know if I necessarily agree with that.
What do you think jurors you've probably tried hundreds of cases by this point in time. I mean, between bench trials and jury trials, because you've done this for you've done this for maybe a few years longer than I have. What do you think jurors are thinking when you're in a situation, and we can, I don't want to name names, but we could probably name names of judges that have made it a point to try to embarrass you in front of the jury. What do you think jurors think of defense counsel, or what do you think they're processing when a judge is just writing you left and right in front of them?
Well, obviously their lens is going to be from, what you've done up to the point that this happens. Assuming that you're still treading water, okay, and you're in play. I think a lot of times juries pick that up, okay? Mm-hmm. Now, what they do with it, remains to be seen. But I think even jurors, sometimes it'll come back and that convict your client will come back and tell you, hey, man, he didn't give you a fair shot. Or, hey, man, I saw when, you were trying to do X, Y, and Z, and he was making sure you didn't get a chance to do that. Mm-hmm. So I think, and especially, Scott, in this day and time where a lot of people are kind of looking around and questioning a lot of things, that they've been told all their lives. I think the sense of recognizing bullies, I think people have a keener radar for that. Mm-hmm. Now, that doesn't give you a license to act like a fool, okay? And it certainly doesn't give you, under any set of circumstances, a license to show disrespect to the court. But I think the idea of that lawyer sitting over there and he's doing everything he can to try to represent this person, and that person sitting up on the bench is doing everything they can to make that hard on him or her. I think jurors pick that up. And I believe in close calls that sometimes they'll give you some credit for that. Now, if you've been just basically sitting in the courtroom while the government puts up a case that's largely unrebutted or, not refuted in cross-examination, there's no competing theory coming to pass, then, they'll slap you on the back out in the hall and say, hey, look, you got a card, I like the way you did it. But I think when they're trying to make up their mind, and one of the things that's present in their mind is that he's not getting a fair shot at this, I think that resonates with jurors.
So you're talking about a situation where you do have a defense, you are putting up a competing theory, you're being respectful, but you're being an advocate for your client. You're asking good questions on cross-examination. You're raising objections. You're responding to objections. But it just seems like, in spite of all of that, that you're not getting treated fairly, and the judge is coming down on you a little harder than the state or the government. You think in that situation, maybe a little nod goes your way from the jury if they sense that you're not being treated fairly or that you're being bullied?
I think they pick that up, yeah.
So now that this is sort of a larger topic, and I guess I think your practice is still, I think you've done some domestic, but I've always thought of you as
just enough not to do it again.
Right.
Yeah, I'm all criminal.
Okay, I thought I had seen you at various points in time, like every now and then with the domestic case, but I think of you as a criminal defense lawyer. Tell me a little bit about, you've been doing this for how many years now?
Since 1993, so 28.
When you have a case and you know it's going to trial, what do you do to prepare for trial these days? What's your approach, and what have you learned about getting ready for it and doing a jury trial that maybe you didn't do when you were first starting out?
I had an epiphany one time where I thought, man, I'm fixing to try this case and it's hopeless. My client there's nothing appealing about him. The circumstances are certainly suspicious. You're going to have a cooperating defendant. So to answer the question,
Mm-hmm.
I think the best thing a defense lawyer can do is sit down and prosecute the case.
Okay.
Take the government's discovery, take the government's witness list, and just map out what it's going to look like. How will this look when they try to tell the story they want to tell based on the evidence and the witnesses they have?
Mm-hmm.
I think when you sit down and start doing that, you start seeing some loose boards in the flooring.
Mm-hmm.
You start seeing where, hey, look, this witness has really got to make a leap of faith, or the prosecution, you're going to get to a certain point and they're not able to get from A to B without hearsay, or
Mm-hmm.
you're going to get, to a point where the witness just can't tell the rest of the story. And I've told clients this all along, buddy, they get to go first.
Uh-huh.
All right. So you've got to figure out a way to work your defense into their case. You've got to get this jury's attention as early as humanly possible, because the concept of just waiting around till it's our turn to put up a witness to say something favorable, a lot of times the train's already left the station.
Or there is no witness like that. There's nobody that you can bring sometimes.
Correct.
Mm-hmm.
And so, you're going to have to, and one of the things I've always looked at, if you've got a witness that's saying A, B, C, and D, and if this is true, then if you'll sit down and it takes a lot of time, spending time by yourself, looking at this stuff, maybe having somebody to bounce dumb questions off of, because you never know what some remote question might trigger another question that gets you where you need to be.
Mm-hmm.
So, if you look at a witness's story and you think to yourself, okay, if this is absolutely true, then what else would be true?
Uh-huh.
And I think a perfect example is, when you'll read in a police report about how, the defendant became unruly and I had to do this and I had to do that. Talking about a police report, I was in fear of my safety, blah, 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 blah. And you look up and you realize, okay, this traffic stop occurred at 11:30 at night. And my client's 6'5", 250 pounds. So if he's acting like this, then I'm sure you got on the radio and called for backup.
Mm-hmm.
You've just got to carry the story on out and say, if this is true, then there's got to be other things that are going to be either true or not true based on this story.
Mm-hmm.
And I think that's where you start trying to unearth the story. You really don't have any Perry Mason moments where the witness just confesses from the stand that, oh, by the way, you caught me, I've made all this up.
Mm-hmm.
And I've always thought to myself, as far as cross-examination is concerned, you've got really two levels of questioning. You've got the questioning where you can make them adhere to your line of questioning. And then you've got assuming that goes as well as you would hope, then you've got kind of another tier of questioning where you can really, raise doubt, but you don't have anything that can impeach the witness. But you've made enough progress in effectively cross-examining this witness and proving that they've not necessarily told the whole story on these other instances. And now I can raise the specter of, well, you don't have anything to back this up, or the story you're now telling me, you don't have anyone that you told in time that this happened to you.
Okay, so
and then they're going to say, well, no, I didn't call the police when that happened, or no, I didn't go home and tell my roommate that this had happened. A lot of things that once you've landed a couple of punches on the things that you have control over, you're able to get the jury to really start looking at that witness's testimony like, I don't know how much I can believe of them.
So there's two levels for you in cross-examination. There's number one, there are the facts that you can bring out from what the witness says. So in other words, you take the witness statement, or you take the incident report, or you take the police report, and you know that there are some things in that police report that the witness says that are good for you. And you know from the statement the witness is going to say those things. So it sounds like your first level is you're just getting out of the witness's mouth those things you know the witness will say that's helpful to your case. And then it sounds like the second level is for the things that are bad for your client, or the things that are good for the state or for the government, you're trying to elicit the fact that, well, first of all, if they come in and they say something they'd never written before that's not in the police report, that's impeachable stuff. But then you're also, it sounds like the other level you're going to is, okay, you said that, you were on the side of the road with a guy that was 6'5" and he tried to fight you. And yet, isn't it true you never got on the radio and called for backup? Isn't it true that you, whatever it was? I mean, so in other words,
yeah.
you're then going to the lack of evidence to support what he's saying.
Correct.
And you do all of this under the larger umbrella of how would I prosecute this case if I were prosecuting it?
Yes. If I had a witness that, if I were a prosecutor and I had a witness that I knew I needed the jury to believe, no matter what, am I going to go out and try to find something that corroborates this witness's story? So like a good prosecutor would think, well, okay, let's get his cell phone records, and it'll show where he called somebody and said, hey, man, I'm out here alone, or something along those lines. So you have to start looking for them, because the last thing you want to do is ask about these questions, and then the guy say, yeah, I got it right here. So
right.
But yeah, you want to look at it from the perspective of, well, if what you say is true, then there are other collateral issues that would either be true or untrue based on the story you tell. One of the things that I've found in the past is it's usually more beneficial to try and get out of the way first. I had a lawyer tell me one time, dance with them as long as you can, because you're going to have to fight them sooner or later, but dance with them as long as you can. So a lot of times, if you can start out your cross maybe with getting some things out of the way that both of you would agree to, it sometimes can take the edge off the witness, and, then maybe they're going to relax and you can get somewhere with them, because a witness is looking at you like, I'm ready for you too. And I've heard about what an ogre you are and blah, 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 blah. I had a police report one time that was like 5 pages long. And somebody's like, man, that's got to be the most daunting thing in the world. And it's like, no, man, that's perfect. There's no way they're going to parlay every single thing that's in this police report. The most difficult police witness I've ever had were those ones that just won't talk to you at all. And I can't remember his name, and I wouldn't say it if I did, because he was a friend and he was a cop, and we were trying a jury trial, and he was a responding officer. And he really didn't know anything more than what he was told. He shows up and the victim says, hey, man, his client did A, B, C, and D to me. And, without getting into all the dynamics of the case, he just had too much pride to say, I don't know. And the more he insisted that he did know, the longer I continued to cross-examine him. And so we take a break. And it was in front of a local Clay County State Court judge. We're out in the hall, and he's gone to the end of the hall, and I'm standing there right outside the courtroom, just kind of biding my time. And I'm looking at him, and he's looking at me. And he says, hey, man, don't talk to me. And he might have used a couple of cuss words and everything. And I walked towards him, and I said, let me say one thing to you before you walk off. I said, you can call me anything you want after this. I said, but here's the thing, buddy. I said, all you had to say was, I don't know. I said, but you were too prideful to say that. And I said, and that just made this torturing experience that much longer. I mean, if you'd have said it, I tried one down in Griffin State Court one time, and it was a Georgia State trooper. It was a DUI, and there was a glaring issue with his report. And I had probably 3 pages of just subjects for cross-examination, because I was certain he was going to get up and just basically regurgitate his report. I get him up on cross, and when we get to that point in the report, he beats me to the punch and says, yeah, man, that's wrong. I made a mistake there. And so 45 minutes of, just on the edge of your seat cross-examination just goes up poof.
Because he said, I made a mistake.
He said, I made a mistake. And, at that point, I kind of look around, like, hey, look, man, I need to pick up some speed. I had all these plans. And he said, I made a mistake.
What else do you do to prepare? So first thing you'll do is you'll take it from the prosecutor's perspective, but say a little bit more about and I've watched you do jury selection before. Tell me about what you do in jury selection, how you voir dire a jury.
I've attended seminars on this.
Mm-hmm.
I've read books on it. It's the most aggravating voodoo, luck of the draw.
Well, you go to those seminars, and the seminar people always tell you to do these things that you get all excited about doing, but then when it comes time to think about doing it, that some of that stuff is not going to work. And
the judge is going to shut you down
in a hurry.
And then you're going to have really what's, my side of the table's worst nightmare, and that's getting paddled in front of the jury before we ever even get started.
Mm-hmm.
And so you have to be careful. Now, one of the things that I have, you need a judge that's going to give you a little bit of latitude. And then, at some point about 2/3 of the way through picking this thing, they're going to look at you and say, hey, look, man, you need to pick up the pace.
Mm-hmm.
And then you try to do, but the one thing that I've seen that makes jurors respond to you is if you talk to them like you're just another human being.
Uh-huh.
If you get up there and you start trying to throw around a couple of words and act like you're something else, then they're just not going to come to the middle of the street for you.
Mm-hmm.
They're just going to look at you. Some of them are going to think you're arrogant. Some of them are going to think worse of you. A lot of them are going to look at you like, I can't trust you.
Mm-hmm.
You're sitting around here strutting around like, some sort of rooster. And, you're trying to act like you're real important. I see the trial judge rolling his eyes at some of the things you do, or something, or whatever. But I had a jury one time, and my co-counsel took the first panel, and he came back and he sat down and he looked at me and he said, man, I can't get these people to do anything. He said, are you willing to take the second panel? And I said, yeah. I said, let me do that.
Mm-hmm.
So I get up there, and the first thing I tell them is, I said, you know what? First thing I do is I tell them, hey, man, my name's Steve Frey. I'm married. I've got 2 kids. And I give them I do a little bit. I tell them, hey, what's good for the goose is good for the gander. So I'll tell you a little something about me.
Mm-hmm.
And then I look at them and I tell them, and you'll usually get a little wry grin out of them when you say this. I say, you know what? I really think this is aggravating as hell too. I said, but they're going to make us do it. So if we work together, we can get through it a lot quicker.
Mm-hmm.
And you'll see them just kind of smile like, yeah, this is aggravating. I think you're asking me stupid questions. I think you're asking me questions of which are none of your business.
Mm-hmm.
But they kind of look at you like, okay, you swore to me if we work together, we'd get through this sooner than not.
You kind of make yourself a juror in a way, because you say, look, I'm going to reveal things about me to you before we get started, because you're going to have to do the same thing. And then you say, listen, I realize this is awkward. It's awkward for me to ask you these things. And that disarms them a little bit.
It disarms them a little bit. And I'll tell you what, one time I had a folder fall off the table. And it just, as you can imagine, they explode and everything goes everywhere. And I just had to stop, And one of the things that young lawyers and sometimes old lawyers, they don't realize that 30 seconds of you shutting up and just handling something seems like forever while your heart's pounding and
Mm-hmm.
but it's really not. And if you'll just kind of look at them like, hey, yeah, aside from being a lawyer, I'm kind of a klutz too,
Mm-hmm.
and pick it up and then kind of shrug your shoulders. They like to see you being humble back to them.
Mm-hmm.
And then they kind of have at least 50% of the ownership in this. And you'll get them a little bit more out of them a lot of times. Now there's no surefire method. You'll have some of them that just look at you like, I'm not going to like you. I'm not going to like you no matter what you do.
Mm-hmm.
I think you're willing to lie to me. I think your client's guilty. I don't know why, I don't have any idea what you think you're going to tell me. And I'm going to be suspicious of you, the entire time. But I think it's really, I think if they believe that you're treating them with the respect that they deserve, if you're showing them that you appreciate the fact that really they're not thinking about what's going on here, they're thinking about all the things that they're falling behind on because they are here. The fact that their boss is looking at them going, I'd fire you except federal law won't let me, or the fact that you look at them and you go, hey, man, I know this is a huge pain in your neck, but I appreciate you.
So it sounds like to me, you see the big part of jury selection. And I know that you're looking to identify those jurors that you have to strike or those jurors that you have to get rid of for cause. But it sounds like to me that you see jury selection primarily, and correct me if I'm wrong, you may not be saying this, but you see jury selection primarily as the way to build trust with your jury, to have them understand who you are and where you're coming from, and to be receptive to hearing what you have to say.
Yes. Because the state gets to go first, there's going to come a point where you're just going to have to sit down and be quiet, and they get to parade their witnesses back and forth. But the home run is when you convince them that there's going to come a time where I'm going to ask you to pay attention to a certain thing because I'm going to parlay that into making you think. And if you can get them to look at you like, all right, now I'm going to hold you to it. You're going to have, there's going to need to be some meat on the bone. But when you holler at me, I'm going to pay attention to you.
Is that something that you try to signal in jury selection? Is that something you try to signal in your opening?
I had a case one time where my foreperson ended up being a female. She worked at the airport. And I remember, I'm getting goosebumps thinking about her. Because it was a case that probably, there should have been a disposition other than a jury trial, but the client insisted on it. And so I knew that I was going to have a jury that was going to have to wade through a lot of things that, was going to cast suspicion on us, And so I remember asking her, she worked at the airport. She had some managerial position. She was responsible for other people. And she's staring me into the blacks of my eyes while she's answering my questions. And I remember asking her something along the lines of, I said, now look, I said, if you were at work and you had a red flashing light, that light signals that you're to evacuate the building, that you're to turn and tell all of your, these people beneath you that you are to, to run like hell. And I said, but you knew that was wrong, that this was misinformation, that you knew that this was a false alarm. I said, would you have the courage to stand up in the middle of the room and tell them to stand down? Don't go anywhere. I've got you. I've got this under control. You're going to be okay. Just follow me. And buddy, she looked at me and she answered every single question with yes, and all the way up to about hell yes. And they acquitted that guy. And she was the foreperson. I was telling that story to a prosecutor. She did a little private work, but she was always a prosecutor. Once a prosecutor, always a prosecutor. And she laughed and she told me, she said, Frey, all I've ever picked was the foreperson. She said, I settled on the other ones. She said, but I wade into that group and I find the one that will tell the rest of them, follow me.
Oh, so she selects for the foreperson.
Yeah, she said, I try to find, now she did mostly misdemeanors, so she's only looking for 6 of them. But she said, yeah, of the 12 they put in the box, we're both going to get 3 strikes. I'm looking for juror foreperson number 1, and then 2, 3, 4, 5, and 6. So and she said, and as long as I cinch the one that I believe will be the foreperson, the rest of them will follow.
And do you think as defense counsel, you're looking for a foreperson that's open to you, or are you trying to eliminate all potential forepersons?
Well, Scott, the one that you like, they're going to be S1.
Right.
So, the idea of this ideal juror just sitting over there in the back left-hand corner, the other side sees them too. So what I have found, my father, I used to listen to him tell stories about picking jurors. And back in the late 80s, when Eastern Airlines was falling apart, and there used to be a lot of I can't remember the dynamics of it, but Eastern Airline employees, they had that union fight that, say no to Lorenzo. I can't remember all the details, but what Pete pointed out to me is he said, son, this is the perfect person that's willing to stand up and poke the bear in the eye and say, not on my time.
Mm-hmm.
I'll die on this hill before I let you bully me.
Mm-hmm. So you're looking for the juror that maybe for whatever reason has been maybe disenchanted with authority figures, who
yes,
or maybe who knows what it's like to be treated unfairly.
Yes.
Mm-hmm. And do you find that you're generally able to find those jurors during jury selection?
The difficult thing about it is that the person you're describing is usually not the person you gravitate to at a cocktail party. So they're not going to be someone that's just, glowing with the invitation of come to me, So you do look for that person. You want somebody that would be willing to stand up and tell the rest of the room, I'm not going to do it.
Mm-hmm.
We used to try to lump folks in more generally and say, well, my client looks like XYZ, so I'm going to get jurors that look like XYZ.
Mm-hmm.
And in some jurisdictions that works for you because maybe you've got a little more XYZ in the jury pool. But I tried a case in South Georgia, and I picked a juror that looked a little more like my client. And I realized, I kind of got to thinking about it as, we went home and I thought, at the end of the day, okay, and this was down in Irwin County, Osceola, Georgia.
Mm-hmm.
Because you think, man, what happened to that person in the jury room? And you thought they stood up for you for a little bit, but at the end of the day, they got to live in this community.
Uh-huh.
And, the notion that they're going to just pick up your client's cause, just because maybe they have some commonality with them and take a chance, and that's a lot to ask a juror, to, hey, man, you need to tell these other 11 people that they're wrong. So you end up at the end of the day, it's that anti-establishment person that's willing to tell 11 other people, I don't care what you think. I'll tell you what, an interesting story. So I'm trying a shoplifting case in Clayton County State Court back in the 90s, and the jury's hung, okay? Mm-hmm. And at one point, the judge was like, well, can you give me a number? Don't tell me what the score is, but just tell me, what's the number? And they were like 5-1. And I remember thinking, it's that old woman on the back, come on, quit being hard-headed. Because at this point, I think I'm winning, okay? Mm-hmm. And I'm thinking that the old woman's the one holding out. Uh-huh. Well, she was the one holding out, but she was the only one holding out for an acquittal.
Uh-huh.
So you just never know.
Right.
And I tried one in Henry County in front of Arch McGarity. And, he and I didn't always get along on points of law, but I always enjoyed Judge McGarity's company. He was a ton of fun to be around.
Always.
And we're trying the case. And I'll never forget, they're home, and it's 5:30 and he's looking at his watch and he said, and the state wants the Allen charge and the dynamite charge, and they're going to give it.
For those that don't know, what's the Allen charge?
The Allen charge, I'm kind of wading into your territory here, Scott. The Allen charge largely is where the judge tells the jury that this has been thoroughly tried, that both advocates have done as good a job as going to be done. The case is laid out as well as it's going to be laid out. You're the best jury to determine the issues in this matter. Now, I need you to go back and keep working at this. So here's what Judge McGarity does. He gives the Allen charge. And I think he's found out the dynamic, and it's 11-1, okay? And we all know that it's not likely 11-1 to acquit.
It's almost never 11-1 to acquit.
No.
Right.
So he looks at me with that old rye grant he's got, and he said, man, it might not be a bad idea. Start thinking about striking a plea. And my client, rest in peace, he passed away in 2020. Hey, I ain't playing to anything, so we're hanging out. And then McGarity says, he said, I'm going to step in there and see if they want to keep deliberating or do they want to, go get dinner, let's get their pulse and see what they want to do. It's late in the day. Do they want to come back tomorrow and everything? And so I'll never forget, he comes back out of the jury room and he's got this look of astonishment on his face. And he says to me, and I can't remember, it might have been Jim Wright. He said, well, I asked them if they wanted to keep deliberating or if they wanted to take a break, what they wanted to do. And he said, and this voice popped up from the corner of the room and said, well, it's 11-1 now, it's 11-1 after dinner, and it's 11-1 tomorrow morning.
Mm-hmm.
And he said, so we talk. They found him guilty of the misdemeanor, but hung on the trafficking in amphetamine. So, so we take a mistrial. He declares a mistrial. And then he looks at me and he says, I'll bet you lunch. I'll give you 6 guesses. And I'll bet you lunch you can't figure out which one I was holding out for you.
Mm-hmm.
And so I gave him 6 incorrect guesses.
Uh-huh.
And he says, no. And then he says, hey, man, do you remember the dude on the front row, kind of to the left middle? And then I was able to describe the guy. I mean, the dude with the curly hair and glasses. And he was like, yep, that's him. And I looked at him and I said, Judge, I said, if you'd come out here and told me I'll give you 10 more minutes to argue, I'd have never even looked at him.
So you just never know.
You never know, man.
Mm-hmm.
And I'll tell you something else, too, that kind of intertwines with that story. A lot of lawyers, will have somebody that kind of raises their hand and goes, yeah, I know Mr. Frey, blah, 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 blah. And then your ego sometimes will say, well, let's leave them on the jury. And that's not always the best move.
Right.
It's really not. I mean, you've been to cocktail parties and they've heard you yuck it up and tell war stories and stuff. And a lot of times they just don't turn out. As a matter of fact, I would be willing to say many, many more times than not, they're not the jury you think they're going to be.
Mm-hmm. Mm-hmm. Well, listen, I appreciate you coming on this podcast with me. I'm going about to wrap up. Is there anything, I think probably the audience is mainly lawyers. Is there anything that you want to, that I didn't ask you about that you really want to say, or anything that you want to say to the folks that are listening?
Well, one quick thing, because when you told me you were going to ask about my dad, I thought, as a 55-year-old lawyer, what would I have told Stephen Frey, fresh out of law school, with a father that practiced law? I would have said, son, this is going to get you to some places a little quicker maybe than everybody else to the pack. But at the end of the day, what's going to sustain you is proof that you're willing to roll your sleeves up and do anything and everything. Serve your own subpoenas. Go, now I learned a little lesson about interviewing your own witnesses, because you can't become your own witness when they look at you and tell you something they didn't tell you. But one of the things that I learned with Pete is that, hey, man, you're going to run into a lot of his friends and you're going to run into some people that aren't his friends. Mm-hmm. And so this notion that you're just going to make the varsity team without ever putting on pads is wrong. And if you really want to take advantage of having that boost, that extra, hey, man, this is my son, do it by working your fanny off. Mm-hmm. I remember one time, and I'll close with this, I did try a case with Pete where, he did all the lawyering and I was just, and it was in front of Bill Eisen. And we had this one particular point that we felt like we were going to make hay all day on this point. Okay.
Uh-huh.
And, we got to the tree, we barked up at a bunch, we got a little something, and then it kind of got shut down. And, it got shut down because the other side had done a little research that we hadn't. And I'll never forget, Bill Eisen tells me, and only the way he could, when I seen, we're in the hall or something, and he looks at me and he said, one of you boys has got to be the one that goes in the library. Y'all all can't be show horses. One of y'all got to be a mule.
Right.
Scott, I thoroughly appreciate this. I can't tell you how honored I am for you to ask me to have done this. I do appreciate this. I think you're a wonderful lawyer, and I'll be forever in your debt for having asked me.
Well, the honor is all mine, and I really appreciate you coming on. Well, thanks so much. I really, really appreciate it, Steve.
Thank you, buddy. I appreciate you.
Thanks for listening to The Advocate's Key. For more information and content like this, including a transcript of this episode, be sure to visit scottkeylaw.com, and please rate, review, and subscribe to this show wherever you get your audio content.